weekend and welcome to this Doughty Street webinar on Zambrano child cases and challenging Zambrano decisions. I'm Agata Patyna, and hopefully you can also see my colleague from the immigration team, Simon Cox, who will be presenting this seminar. For those of you who are new to Zoom or haven't attended a webinar before, you will notice that your mics are muted and your videos are off. And that's just a presetting, so don't be alarmed. It stops any background noise, any interference. Simon will present for about 30 minutes, and then we will have a Q&A section at the end of the seminar. But please feel free to post questions as Simon speaks. The way to do it is to use the Q&A function on your screen rather than the usual raise hand function on Zoom. And then I will then pass on any of your questions to Simon. You also have a chat function which lets you post any comments you want to share with everyone on the webinar. So if you have any interesting cases you've recently dealt with or intelligence you want to share, please do. We will aim to finish the seminar at 4 on the dot. So if we don't have time for your questions, we will try to respond to those by email. And we are also recording this webinar, and a copy will be available on our website, but also on Twitter at Doughty Street Im soon after we finish, for you or for any colleagues who couldn't join today. So I'll hand over to Simon.
Thanks very much, Agata. Hello, everybody. I hope everybody's keeping well. We thought it would be useful to talk through some of the issues around Zambrano cases after talking to quite a lot of solicitors and other advisors who could see problems. Obviously, we have at the moment only a little over 6 months left before the end of the transition period, after which we move into a state of, at the very least, uncertainty about Zambrano cases. So this may be the last chance that people have to get it right, to persuade the Home Office, and to be bringing successful appeals from their decisions. So I wanted to focus on certain issues. But first of all, just to remind ourselves, why does Zambrano matter? So it's maybe the most important right for British citizen children of parents who don't have British or European Economic Area citizenship. In practice, it can prevent the removal of that parent from the UK. It can give them right to reside. It can give them right to have leave to remain under the EU settled status scheme. But also it's a very contested right. So we see Home Office officials fighting hard to try to make sure that people don't have that right. Sorry, just jumping back, sorry. And one small point, it doesn't count as a right to reside for benefits. So from many clients' point of view, it is a right to reside of last resort, but it's still a pretty important one. What's the legal basis for Zambrano rights? Well, the ultimate legal basis is European Union law. It's Article 21 of the Treaty on the Functioning of the European Union, and it comes from the case of Mr. and Mrs. Ruiz Zambrano, Ruiz being their patronymic, Zambrano being their matronymic. Unfortunately, they've lost the formation of their name in an anglicised world. They've lost half their name. But that's the basis for the right, is EU law. But where we look to it, and as I'll be going through in this short webinar, we look to the regulations that implement the right into UK law. And what we've seen over the years is a number of cases that have challenged those regulations for being too narrow, too restrictive. But what we'll see is that in many important areas, the regulations are actually quite generous at the moment. They're more generous than what the Home Office say is the correct interpretation of Article 21. But those Home Office staff haven't been able to persuade their colleagues to amend the regulations. So that means that for now, our clients have the rights that the regulations give them. And as we'll see, the case law that the Home Office rely upon is about what Article 21 says, not what the regulations say. Now, what this webinar is not about, who this webinar is not about, this webinar is only about the parents and carers of British citizen children. There are some other considerations that apply where the British citizen concerned is an adult, and there are other considerations where the child is a citizen of another EU country, not the United Kingdom, or where those rights are based on the child being the child of a worker under the Ibrahim and Teixeira rights. And the last thing we're not covering is we're not covering the other members of the family apart from the parents. We wanted to keep it quite narrow and just focus on the parents of children. Now, there are four things that I'm going to be talking about as I go through. The first is whether or not the Home Office are right to be saying that applicants who have limited leave to remain or who could apply for it are shut out of the Zambrano rights. I say that that's wrong under the regulations. The second argument that the Home Office use is that the child has another parent, usually, who can care for the child. British citizen parent or a parent who has some other right to reside and isn't threatened with deportation. I'm going to show you that the regulations rule that argument out too. The third problem is where the applicant is threatened with deportation. I'm going to take you to the regulations that show that deportation can't proceed until a decision has been taken under EU law to exclude that person from the UK. And lastly, on settled status cases, and it's a similar point to the first one I mentioned, that whether or not applicants need to apply, in particular under Appendix FM, for leave to remain before they can be eligible for receiving settled status. And I'm going to show you that that isn't what the rules say. So the first point here is that the Zambrano rights fall within the scheme of Regulation 16 of the 2016 regulations. This regulation covers a number of different rights. And so we start with paragraph 1 of the regulation, which has two requirements. The applicant is not an exempt person, and the applicant satisfied each of the criteria in one or more of paragraphs 2 to 6. And as we'll see, it's paragraph 5 that we're interested in. And that's the basic regulation. So those criteria, there are 3 of them, and 2 of them are reasonably simple for the cases that we're talking about. The first criteria is the person is the primary carer of a British citizen, and we will be exploring that first in the case of a single parent, and secondly in the case of where there are 2 parents of the child. The second criterion is that the British citizen child here, talking about children, is residing in the United Kingdom. And the third criteria, and this is the one that the Home Office are willfully misunderstanding, is that the British citizen child would be unable to reside in the United Kingdom or in another EEA state if the person, and that's the primary carer, left the United Kingdom for an indefinite period. And the crucial word here is if. If the person. That's the criteria. It's a hypothesis. It says, if that person left, would the British citizen child be unable to reside in the United Kingdom? It doesn't say the person is required to leave the United Kingdom. That's not the legal test under the regulations that the Home Office has made. Now, you'll remember a few seconds ago, we said that exempt people are excluded from the benefit of having a Zambrano right to reside. Now, there are 4 of them. The 3 crucial ones are set out here. The first is someone who's got a right to reside under another regulation. So, for example, someone who is the family member of an EEA citizen, or maybe is an EEA citizen themselves. They may have a right to reside as a qualified person, as a family member of a qualified person. Then they aren't recognised under the regulations as being able to have the Zambrano right to reside. The second group of people is people who have the right of abode under Section 2. Well, the most important category there is British citizens. So a British citizen is an exempt person. They can't have the Zambrano right to reside. And the third group is people who have indefinite leave to enter or remain in the UK. Now, as we'll see, the class of exempt people is important for a second reason that we'll come on to. I just wanted to show you that definition. Now, Coming back then to this first Home Office argument, does the applicant have to show that they would have to leave the UK? So the Home Office guidance on derivative rights says that you must consider whether the applicant either already has leave to enter or remain in the UK, or if they could make an alternative application for leave to remain in the UK. This is the Home Office guidance to their officials. If alternative leave to enter or remain is held, or other avenues for leave are available, the British citizen would not be forced to leave the UK and the EEA. Well, that may well be relevant for whether or not Article 21 can be relied on, but it's not in the EEA regulations. The EEA regulations don't talk about the applicant needing to have some other form of leave to remain or being eligible for some other form of leave to remain. They just asked a hypothetical question. If they had to leave the UK, would the child? What the regulations do exclude, as we saw, is they exclude applicants who've got indefinite leave to enter or remain in the UK. Now, maybe the Home Office could amend that, and they could add people who've got limited leave, or they could add people who would get limited leave if they applied under the rules. But that isn't what the regulation says. Now, what's the basis of the Home Office's argument? They say it comes from Patel in the Court of Appeal. Yeah? They say that in Patel, the Court of Appeal ruled that someone holding leave to remain under domestic law would not benefit from a derivative right to reside. That isn't quite what Patel said. Yeah? The court also ruled, they say, Zambrano is not a backdoor route to residence for those who have a British citizen child without having or acquiring leave to remain. The court did use that phrase, and we'll look at in a moment at the context of that. And then what the Home Office says, this means that a Zambrano application must be refused if the applicant has never made an application under Appendix FM or has been refused under Appendix FM, but their circumstances have changed since the decision was made. Well, it doesn't say that in the regulations. And Patel wasn't interpreting the regulations. What Patel was interpreting was what Patel calls the Zambrano principle. Because in the case of Patel, the appellants were arguing that the regulations weren't big enough to meet the requirements of EU law. But the court wasn't saying that the regulations could somehow be shrunk down by the court because EU law didn't give someone a right. That isn't the court's job. The court's job isn't there to take away things that are spelt out in regulations because EU law doesn't require them. That's the Home Office's job when they make the regulations, to choose how big or small they make them. And they've left them broad. They haven't shrunk them down. We can also see in Patel that the court said that Ms. Smith, that's the Home Office's counsel, pointed out that Mr. Bereza had never made an application for leave to remain in the UK. The judge said, well, might have been able to make an application. And then the judge said, cannot bear upon the decision we must take. Why? Because the regulations didn't say anything about people who could apply for leave to remain. The only thing the regulations said was people who'd already got indefinite leave to remain. And then we see also in paragraph 68, they point out that if this man had got leave to remain, then he wouldn't need the Zambrano principle. But we're not talking about people who are relying on the Zambrano principle. We're talking about people who are relying on the regulations. In short, what the court was asking in that case was, what does EU law require the UK to do? Not, what do the regulations say? So let's look then quickly at what a single parent has to show. First of all, they count as a direct relative. Secondly, the child's a British citizen living in the UK. And then remember the wording of Regulation 16(5)(c). The child would be unable to reside in the UK or in another EEA state if the parent left the UK for an indefinite period. Here, the Home Office guidance is helpful. It explains that you mustn't refuse an application. Caseworkers mustn't refuse an application on the basis that the British citizen child has a right of free movement unless the applicant is an EEA national. In other words, this doesn't apply to applicants who aren't EEA nationals. They don't need to show they can't live in the EEA. The only thing they need to show is that the child couldn't live in the UK. Well, if you're a single parent and the child is cared for by you, you might think that that was fairly easy to show. We'll come back to the argument that the Home Office have about alternative carers in the context of a couple. So let's look at what the regulations say about a couple. And they deal with this very specifically in paragraph 8 of Regulation 6. They say a person is the primary carer if the person has primary responsibility for AP's care, that's essentially the single parent case, or shares equally the responsibility for AP's care with one other person. Sorry, I just clicked that by accident. Shares equally the responsibility for AP's care with one other person. Now, as we'll see, this was amended. It used to say who is not an exempt person. So it used to rule out partners who were both parents of a child where the other partner had a right of abode, was a British citizen, or had indefinite leave to remain. But that was removed from the regulations. We'll come back to that. But that's the basic requirement for a couple. Yeah, they have to be a direct relative, for example, a parent, and they have to share equally the responsibility for care. Now, notice what's being shared is not the care; it's the responsibility for the care. And here again, the Home Office guidance is really helpful. The Home Office accepts that there doesn't have to be evidence of equal sharing of the responsibilities. They give the example of the father who does not provide the majority of care for the child, where the father is actively involved in the child's life and has parental responsibility for the child. Why? Because if you have parental responsibility for the child, then you're sharing the responsibility for care. You may not personally be providing the care. You may be out working all day. Someone else may be providing the care. Your partner may be providing the care, but you're sharing the responsibility. And that's very clearly accepted in the Home Office guidance. In fact, what they say is the only cases where you shouldn't accept shared responsibility are where there's evidence to indicate the father is unable to care for the child. So what if the other parent is British or has indefinite leave to remain? We know that the Home Office are saying that that excludes you from eligibility for Ruiz Zambrano rights. But that used to be the case. At the time of Patel, the regulations excluded people who were in where the other carer was an exempt parent, an exempt person, sorry. But that was deleted in 2018 by the amendment regulations in 2018. And so these words here at the bottom of paragraph 8 were deleted. Now they're still there in lots of old versions. I got a reasons for refusal letter last month where the Home Office have put that in, but it's not there anymore. And that's really crucial because it means that you don't lose your Ruiz Zambrano right if the other parent is a British citizen or has indefinite leave to remain. You don't lose it if they have limited leave to remain. We've already seen that. It doesn't matter what the immigration status is of the other parents, doesn't affect your Ruiz Zambrano right to reside. So we can now see how the regulation, feeding this provision about joint carers, or people with joint responsibility, back into the primary definition. We see, remember those three criteria, the person's the primary carer of a British citizen. Well, we've seen that primary carer includes where two people care, yeah? And where they both share responsibility for the care equally. So in this situation, I'm the mum and I work full time and the dad stays at home and cares. But I'm the one who's threatened with deportation, right? So I share the status of primary carer. My child is residing in the United Kingdom. And the Home Office say, well, it doesn't matter if you get deported, mum, dad can stay and look after them. Look, he's already looking after the kids full time. But that isn't what the regulation says. What the regulation says is, would the child be unable to reside in the UK or in another EEA state if both primary carers left the UK for an indefinite period? Not that they must leave the UK, or that they will be forced to leave the UK, or that they don't have a right to reside in the UK, just if. That's the test in the regulation. if both primary carers left the UK. So if mum is threatened with deportation and dad is a British citizen, then the question is, if mum and dad had to leave the UK for an indefinite period, would the children be unable to reside in the UK? Turning then finally to the last two questions, issue of criminality, deportations, and the issue of the settlement scheme. The Zambrano right to reside isn't lost by a normal deportation order. It's only lost by a deportation order that's been made under the European Economic Area Regulations. And we get that from Regulation 1612 of the regulations. That is the exclusion. There's no other exclusion for a Zambrano right to reside. So what you'll find quite often is that your client is not an EEA citizen. They're subject to a deportation order made under the immigration rules and under the Immigration Act with no reference to the EEA regulations. But in fact, at the time that the order was made, or later, they became a Zambrano parent. They became the parent of a British citizen child, and they became someone who had primary responsibility for the care of that child, often alongside a British citizen parent or a parent with indefinite leave to remain. The deportation order can't operate to deny them their Zambrano right to reside. There must be a second decision under the EEA regulations, and you'll know, of course, that the basis for making an EEA deportation order is much narrower than under other domestic law. The state has to show that the person poses a genuine and current threat to a significant public interest. It's not enough to show that they had previous criminal convictions, and the test for proving that it's justified is much more demanding than the test under the immigration rules or under the amended Nationality, Immigration and Asylum Act. Lastly then, the settlement scheme. The definition of a person with a Zambrano right to reside has two parts. The first part is what we've just talked about. Resident for a continuous qualifying period in the UK with a derivative right to reside by virtue of Regulation 6.1 by satisfying the criteria in paragraph 5 of that regulation. In other words, the person has a Zambrano right to reside. The settlement scheme adds two extra hurdles. The first is in the definition of a person with a Zambrano right to reside. And there's the requirement that the person does not have leave to enter or remain granted under another part of these rules. Note, it doesn't say could apply for leave to enter or remain under these rules. It doesn't bring in through the back door the idea that your client has to apply for Appendix FM leave or any other form of leave under the rules. But if they've already got it, or if the Secretary of State just decides to give it to them, then for the period of that leave, they don't have the Zambrano right to receive pre-settled status, and they don't have, and that leave doesn't, and that period of leave doesn't count towards the 5-year period for completing, for obtaining settled status. The second hurdle that the settlement scheme imposes is that people with a Zambrano right to reside are excluded from the settlement scheme if they're subject to a regular deportation decision, a deportation decision under the immigration rules and under the Immigration Act, not under the EEA regulations. So we have three kinds of people here. We have people who have the Zambrano right to reside, and that counts under the settlement scheme. We have people who just have the Zambrano right to reside, but that doesn't count under the settlement scheme either because they've also got leave under the rules, or they're subject to a deportation order under the Immigration Acts. And then we've got the third kind of people who don't have a Zambrano right to reside anyway, because they don't meet the criteria in the regulations. What the regulations don't, the rules don't require is that you've already got a Zambrano residence card, though for tactical reasons, and let's talk about that in a moment, you might want to apply for one anyway. And you don't have to have applied for leave to remain under Appendix FM, as I've explained. So we can see, in flipping it around, who is then excluded from the Zambrano right to reside? EU citizens with a right to reside as a qualified person, People with a right to reside under EEA regs as a family member of an EU citizen. People who could not exercise their responsibility for the British citizen child's care. They don't count as a primary carer. And people with indefinite leave to remain under the immigration rules. And then we have one extra class of people who are excluded from the settlement scheme. That's people with limited leave to remain. What to expect in practice? I think from the limited experience we have, but really look forward to hearing what you're saying in the chat and what you're going to raise as questions. The Home Office ignore these provisions of the regulations, and they talk about their own guidance. So in cases that I've done where we put forward amended grounds of appeal, setting out exactly these points, and the Home Office have said, we'll write a supplementary refusal letter. The Home Office comes back and says, well, but if you're deported, their mum can look after them. Doesn't mention the regulations, might mention Patel, but doesn't mention the regulations. They know they haven't got a legal leg to stand on. That's my view. But let's talk about your experience. So summarising, those are the points that people can use. It's the EEA regs. It's the 2016 regs that set out what the law requires, not Patel. Patel sets out what the EU law requires of the UK, not what UK law requires of applicants. It's the regulations that set that out. The regulations ask if the parents or the parents have to leave. It doesn't ask, would they in fact have to leave? And the regulations don't exclude people who've got limited leave or who can apply for leave. We know that appeals are being won, they're being allowed by first-tier tribunal judges because they're looking at the regulations and they're not seeing yet any legal answers to the points that we're making. And of course, if the settlement scheme application was made after the 30th of January of this year, then there is a right of appeal to the first-tier tribunal from that. So that's my thoughts on the arguments under the regulations and under the settlement scheme. And I look forward to any questions that you've posted in the chat, or any questions that you've posted rather in questions and answers.
Thanks very much, Simon. We have a question from Mohammed, which says this: under the regulations, do you use the right to reside if the child turns 18 in the interim? And what Mohammed means is a case where a client secured a Zambrano permit when the child was, in that case, 14, 15, and then the later application was refused on the basis that the parent must now satisfy the adult carer requirement. So Mohammed is asking whether that Zambrano right was lost, and also asking if the position is different under the EU settled status scheme.
Okay. Well, I think, at the moment, I'd want to think about it more carefully. I haven't thought about those kinds of cases. And as I say, Mohammed, this webinar is really about the child cases. What I would say is that, first of all, that period that person had the Zambrano right to reside runs down until the child is 18. So there may be cases, yours might not be one, there may be cases where you can argue that person has acquired a right under the settlement scheme on the basis of that historic 5-year period. I think otherwise, it's not obvious to me that the Home Office are wrong, that once the child is aged out, that they're over 18, that the different approach applies because the person has then become an adult. What I would encourage you to also think about, may not be true in your case, is whether there are any rights to reside under the Teixeira Ibrahim rule, because under that provision, it can continue past 18 if the child remains in education.
Thank you. The next question comes from Christopher, but it's one that I often get asked by solicitors. It's about tactics and whether applications under Appendix FM or Zambrano are a better idea. Zambrano applications obviously being and usually decided more quickly. So Christopher's client is someone who's a non-EEA national who's a grandparent of a British citizen child, a child who was previously in care, but the client was brought here to assess suitability as a parent or a carer, and has pending or continuing family proceedings, and now has to apply for an extension of her visa. The child is with that grandparent, and it seems that the family court will approve this. And the issue for the client is what to do now, whether to do the Zambrano route or an Appendix FM application, which seems certain to be decided positively, but is more expensive and will take longer.
I think there's a lot of issues there, and it does depend on the client's approach to risk, and it depends on money. I think that the basic points to bear in mind, I think, are these. The first is that there's nothing to stop a person applying for both. The right to receive a decision under the EEA regulations is independent of whether or not whether the person has also made an application under the immigration rules. So one can certainly apply for both. The key problem here is that the advantage of having the Zambrano right to reside is the potential for relying on the settlement scheme and therefore for getting settlement faster. But you're excluded from the settlement scheme if you've been granted limited leave to remain. So what the settlement scheme does force people to do in your client situation is to choose. They can, of course, make both applications, but there's no point making the Zambrano application as a route to getting EU settlement if you're going to also be granted limited leave to remain under the rules under Appendix FM. So I think what one needs to do in those situations is to advise one's client that you can either stay on the Appendix FM route, which will be long and expensive and uncertain, or you can apply instead only under the Zambrano route, which depends on your confidence about whether the person will meet the requirements of the Zambrano rule. And then what advantages that would give them. Now, if in practice this person has had limited leave to remain up until now, then they're not going to qualify for settlement under the Zambrano route for 5 years from when that limited leave to remain stops. So that's the choice that you're asking them to make between getting settlement after 5 years with a Zambrano permit and staying on the leave to remain route for now, but therefore ruling out the possibility of benefiting from the EU settlement scheme with a Zambrano permit.
The next question we have is from Sandeep Basu, and Sandeep says that many people who had a Zambrano permit transferred to leave under the rules, so they could have recourse to public funds, and also prior to 2018 Zambrano did not lead to settlement. And now that it does, the question is whether the person can either A, switch back to Zambrano or applied under the EU settled status on the basis that they have always had a Zambrano right to reside.
Well, I think that's that's another angle on the answer I just gave. I mean, I think that the challenge is that the settlement scheme forces our clients to choose between staying on Zambrano only, not having limited leave to remain, which means that then they're excluded from benefits, but they can get a settlement, or having leave to remain with the possibility of getting the no recourse to public funds condition lifted, but then being unable to benefit from the EU settlement scheme. And it's, you know, if you have clients who've already made the decision to switch to limited leave to remain, then unless someone comes up for an argument with striking down the leave to remain requirement in the settlement scheme, then that person's the time for their 5 years to start has been set back to 0, but by them having limited leave to remain. I think the more difficult cases are people who come now thinking about dropping their Ruiz Zambrano status effectively and switching to Appendix FM, or at least dropping their chance of having it under the settled person scheme, but who are approaching the 5-year time limit. Because if someone is approaching that 5-year time limit, it might be worth holding on and applying for settlement on the basis that they'd now completed 5 years Zambrano with no leave to remain. But as you've explained, there'll be lots of people who did decide that they were going to go on to Appendix FM because the Home Office has used access to benefits as a means of driving them back into the immigration rules.
Thank you. We have a question from Mark, which is about Regulation 11.5e, which allows an application for a right of admission if you can show that the applicant is accompanying a British citizen to the UK, and the person will be entitled to reside in the UK under Regulation 16.5. And he's intending this client to apply for a family permit on this route, where she and the child are both currently abroad, and also pointing out to the Home Office that a parent application will be bound to fail, as that requires the child to live in the UK. Can you see any difficulties with this approach?
That's quite hard to do on the spot, I think. There might be difficulties with that approach if one had time to reflect on it. I mean, on the face of it, seems to me you are right that if you were in the UK, you would have the Ruiz Zambrano right to reside. I haven't looked at, I don't know if you have, Agata, the question of getting family permits under the Ruiz Zambrano rule. You're certainly right, as I understand it, about the inability to apply to the for leave under the Appendix FM. So, I mean, I to be honest, I don't think I would want to dive into answering that question. I'm afraid, off the cuff.
That's okay, and maybe we can deal with the question.
I'll do Nicole's question.
Sorry?
So I do Nicole's question?
Yes, of course, yes.
Okay, so Nicole said, can I go back to clarify how the Regulation 16.5 applies to applies to the case where there are two couples. So let me just quickly whip through the, so this is the basic regulation, 16.5, and it talks as if there's one primary carer. Yeah, is the primary carer. And then the British citizen child will be unable to reside in the UK if the person, that's the primary carer, left the UK for an indefinite period. Now, scrolling forward then to the situation of two primary carers. Well, so just a recap, we've got two primary carers under 8B2. That's paragraph 8B2 of Regulation 16. That's where the person shares equally the responsibility for AP's care, which here is BC also, British citizen's child care, with one other person. Now, what does that mean for the regulation? Well, it means this. Regulation 16.9 says that in paragraph 5C, if the role of primary carer is shared with another person in accordance with paragraph 8B2, the words the person are to be read as both primary carers. So, it doesn't change 5A. The person, which is now means one member of a couple, is the primary carer. They are a primary carer, they're one of two. The child is residing in the United Kingdom, but Regulation 16.9 rewrites 16.5C. It says the British citizen will be unable to reside in the United Kingdom or another EEA state if both primary carers, yeah? Because it tells us we have to delete the words the person, or we have to read the person as if it said both primary carers. So instead of the person, we see both primary carers, and instead we get if both primary carers left the UK for an indefinite period. So that's how the regulation implements the Court of Justice's decision in Vilches-Chavez. So you can look here, and we can share the notes, but I might just try this and see if this works. We can look at the 2018 regulations, and just going to try and see if I can do this with you. Might not work. These are the 2018 regulations. They amended the regulations in lots of different ways. And what they did, he said, is trying to get to the schedule. Here it is. They amended the regulations by putting in, they amended them by deleting who is not an exempt person. Yeah, so that was the crucial change. The regulations had always had that provision in about two couples, but it used to be that it didn't count if the other person was an exempt person. And the rationale for that amendment by the Home Office, which they haven't changed, is here. Paragraph 10 amends the 2016 regulations to give effect to the judgment of the CJU in Chavez Vilches. It does so by amending the regulations to allow a person to be recognised as a primary carer if they are the sole carer or if they have shared equally the care with another person, regardless of whether that person is an exempt person within the meaning of Regulation 16C. So I hope that deals with your question, Nicole. But we'll share the notes afterwards.
We have a question from Carla, who has a client who, before his visitor's visa expired, applied as a Zambrano carer under the settled status scheme and could not apply for entry clearance as a parent as she moved to the UK with her British daughter. Now, her application under this EU settled status scheme has been refused on the basis that she never applied under Appendix FM. This is the scenario that you discussed, Simon. And Carla says, well, she could challenge this under admin review as the decision is not consistent with Appendix EU, but the problem is that she technically applied under the scheme whilst she had a visitor's visa, so she had leave to remain at the time of applying. And the Home Office could now reply to the admin review and refuse the application on the basis that she never applied under Appendix FM, but on the basis that she applied whilst having existing leave, so not on the Appendix FM basis. Do you have any views regarding that?
Agata, is this a case under the settlement scheme? So
yes, it is. Yes.
So I mean, I think the what the settlement scheme says, and just to go back to that, just moving back to the text of the settlement scheme, without leave to enter or remain in the UK. Now, if the decision under the settlement scheme was taken before the end of the period of the visit leave, then I think they're right. Your client had leave to enter in the UK granted under another part of these rules. But if the decision was taken after the leave to remain expired, then I think they're wrong, because they didn't have leave to enter or remain in the UK under another part of the rules. And if it was the first of those, then your client can apply again, because they don't have any visitor leave now. The rules about leave being automatically continued in Section 3C of the Immigration Act 1971 are not stated to apply to applications made under the EEA regulations. And there might be some EU law arguments there that people have the right to be treated as if they still had leave to remain. But that isn't the Home Office's position. The Home Office's position isn't that an application for Ruiz Zambrano leave to remain automatically extends the leave to remain. So the question would then be whether or not the application under for leave to remain under the settlement scheme does. And I think it probably does. So if the application was made in time when you were still a visit visa and it was for the settlement scheme, then I think that would extend your leave to remain under Section 3C. As soon as they refuse it, if they refuse it without a right of appeal on human rights grounds, then at that point, the leave to remain expires. So I do think then, yes, thinking about it harder, if you make an in-time application when you're a visitor for leave to remain under the settlement scheme, then at the time they take the decision, you do still have leave to enter or remain granted under another part of these rules, because your leave to enter or remain was automatically extended by section 3C. So I think they would be right about that. Even though your client does have the Zambrano right to reside, your client doesn't also have the right to leave to remain under the settlement scheme. But as I say, as soon as they take the decision, unless they recognise that a right of appeal arises from it under the human rights provisions, then the leave to remain stops, and then your client is entitled. So your client would be entitled, I think, on a second application under the settlement scheme to get it, because legally she's now an overstayer.
Thank you. We have another question about couples or separated couples. It's from Joe, and it's about a case where the parents are currently in a family court dispute, and the father is refusing any contact between the mother and children. She's on a visit visa, the mother. Could she still be considered a primary carer? And should she wait until her visa expires, which I guess follows up from your previous answer, Simon?
That's a good question. I mean, the legal interpretation of primary care under the regulations hasn't had so much attention, partly because the Home Office guidance is I think very generous. I think I sense, and I may be wrong about this, but other people may have a view, and it'd be really interesting to hear what people say in the chat. My sense is that whoever drafted this guidance for the Home Office was very reluctant to say that a parent doesn't have responsibility for the care of their child. And I think that they may be concerned about some legal issues there, right? Because a parent has in law a legal duty to care for the child. So it's quite hard if you read this regulation and it talks about shared equal responsibility for care, to then say, oh, well, that doesn't include a legal duty to care for your child, because you'd normally expect to interpret this law in line with other laws. So, I mean, if your client's children are ruled by the family court that she has no responsibility for their care, if, for example, they're adopted and she loses parental responsibility, then that would change. But I would have thought there was quite a nice hard legal argument to put to the Home Office and expect them to come back and say that the mother doesn't have responsibility for the care of her children. My guess is that the authors of the Home Office guidance wouldn't want that to happen. Whether a senior caseworker sees it differently, I don't know, but my guess is that they wouldn't want that to happen.
I suppose in that scenario, the added difficulty for the mother would be the hypothetical question about what would happen to the child if the mother left. And that's where the Home Office might be saying, well, the child has no contact at the moment with the parent, and they fully reside with the father. Do you see difficulties with that?
Yeah, absolutely. And I think that's where it comes back to the wording of the regulation, because under the regulation, the question isn't would the father have to leave, it's if the father had to leave, because he is the other person who's a primary carer. So if she counts as a primary carer under the regulations, he counts as the other primary carer, and therefore the regulation mandates the question, suppose they both had to leave the UK. It's asking a pure hypothetical question. It's not going to happen. Yeah, he's not going to leave, but that's not the legal test. The legal test is if.
Simon, you spoke about the interpretation of the regulations rather than EU law with reference to Patel. One of the questions we have is, putting aside the domestic regulations, do you think the policy of requiring an application for leave under Article 8 can be compatible with EU law, let's assume that the Secretary of State amended her the regulations.
I mean, I think that's a much harder argument, and I think that's where Patel comes in, because I think Patel does, Patel recognises that the legal rationale for the Ruiz Zambrano case was cases where EU law needed to step in. So I think I would put it a bit differently. I would say, does the Zambrano rule stop the state from attaching conditions to your leave to remain? So we could see, for example, I mean, Appendix FM leave meets the requirements of Zambrano. It means that that person won't be required to leave the UK. The problem with Appendix FM leave is it may be subject to a prohibition on recourse to public funds, and it doesn't lead to settlement within 5 years as it would under the EU settlement scheme. But we haven't got any judgments from the Court of Justice in Luxembourg that say you can't impose a no public funds requirement in a Zambrano case. And we haven't got any cases that say you have to give people permanent residence after 5 years of Zambrano cases. So we don't have any judgments of the Court of Justice that we can point to make those arguments about the practical consequences of the Home Office's two schemes.
Thank you. Another issue which in my experience arises a lot in practice is where a client has a pending appeal under regulations and the only argument before the tribunal is the Patel point, so whether someone should have made a human rights application. Would your advice be to continue with the appeal or to submit an application under the EU settlement scheme?
Well, I think it depends on what the disadvantages to the client are of making the application. So at the one end, you might have someone who has a good case to have been a Zambrano parent for 6 years, and therefore they want to get settlement. Now, if they apply, let's say for 4.5 years, right? That makes it a bit easier. So for 4.5 years, which means they're due to complete their 5 years in a few months. Now, if they now apply for leave to remain under Appendix FM, they're going to lose the possibility of a settlement. So that's, I think, at one, that's at one end of the spectrum. At the other end of the spectrum is somebody who would want to have universal credit, and they're not going to get universal credit if they're only a Zambrano permit holder. But I think for people in the middle, I mean, it may be that we see in the chat, or you may have seen, Agata, tribunals refusing cases relying on Patel. But it doesn't seem to me, as I don't see any real legal argument that Patel invalidates or amends the regulation. Regulation is a freestanding basis for the right to reside. It says what it says, and I don't see Patel amending it. So it seems to me that those people have a very strong case to go ahead and get Zambrano leave to remain, even if they, for their own personal reasons, their own personal circumstances, would want to have Appendix FM leave in some of those cases.
And in my experience, the appeals are decided very narrowly on the interpretation of the regulations, and the Home Office almost concede them at the hearings, but that might be just me speaking anecdotally and being lucky with judges who accept the argument that you've put forward today. We have, I think, time probably for one or two more questions. One is a question and a comment by Rosie about those who historically had a derivative right to reside, but then decided to apply for leave under Appendix FM, and we touched upon it a bit today, but now would like to apply for settled status on the basis of their derivative rights. Now, Simon, you pointed out that the guidance says they must be refused if they have or had an avenue under Appendix FM. But the Appendix EU guidance, Rosie pointed out, also states that where derivative cards were actually issued, this should be taken as a confirmation that another venue under Appendix FM was not viable. And that appears to be a big contradiction, because it leaves people who were issued with a derivative rights card and subsequently leave, that leaves those individuals under excluded. And what's your view on this interpretation or this contradiction?
I mean, I think it's a really good example. I mean, I think we've got a very classic kind of Home Office situation here, in which the Home Office is trying to face several different ways at once. I think it's trying to face towards the European Commission and to comply with the law on Zambrano under the regulations. Then it's trying to meet what I suspect are mostly officials' concerns about giving too many people leave to remain. And in particular, I think we know that Home Office officials and some ministers have always been most resentful of British citizens relying on EU law, more than they've resented EU citizens relying on it. So when the British citizen's a child and the parents are full-blown non-EU foreigner, I think we see a lot of resentment at the top of the Home Office to those people coming in, as the Court of Appeal phrased it, through the back door. So I think that's what produces the contradiction. I think the legal problem with the argument is that the Appendix FM, which is the rules, not the guidance, seems to me is very clear. It says that the person was without leave to enter or remain in the UK, granted under another part of these rules. So if the leave to remain was granted under Appendix FM, then I think for the period of that leave, it seems very hard to argue that that counts towards the 5-year settlement period of the applicant under the settlement scheme. They might be entitled to it now because that leave might have expired, but that period won't count for the 5 years. So I think that the guidance tells us how contradictory their approach is, but it's not easy, at least on this ad hoc quick basis that we're talking now, to see a good legal argument coming out of that for undermining what the EU rules actually say.
Thank you, Simon. It's almost 4, so I think we probably don't have time for any other questions, but thank you everyone for asking so many insightful and detailed questions, and that helped us cover a lot of different scenarios which arise under Zambrano. Simon, I don't know if there's anything else you want to add before we say goodbye to everyone.
No, thank you very much. That's great to have those questions. We've been following some of these debates on the Refugee Legal Group discussion group. We'll make available the podcast, or we'll make available this webinar as a webinar and the notes. And I hope everybody stays well wherever you are remotely.
Thank you very much all. Goodbye.
Bye-bye.